of Rhode Island Coastal Resources Management Council's Rights of Way Subcommittee to order. Today is Tuesday, October 8th, 2024. I would ask that the record reflect the council members that are present this evening, as well as the staff and the council's legal counsel. First matter on our agenda would be approval of minutes from May 28th, 2024. I would entertain a motion to accept those minutes. The motion has been made. Is there a second?
Second.
Motion made and seconded. Any discussion? Hearing none, all in favor say aye. Aye. Anyone opposed? Motion carries. Staff report, Mr. Willis?
No staff report tonight, Mr. Chair.
All right, so first matter, formal matter on the agenda would be hear and decide motions and objections filed by the parties. The matter of Spring Avenue right of way, CRMC file number 2020-11-11-084. So at this point, I'm going to turn it over to Attorney DeSisto for the process this evening.
Well, you've got some motions on and there were some objections to them, so I think we're gonna have to take them one at a time and allow the attorneys to explain why they presented these motions, make their arguments for and against. And then I'm gonna ask you to rule on each one of them. I think that's the best process for it. To start off, I recommend that I see Mr. Langseth in the back. He has a motion to intervene. He contacted me, and unfortunately I was not able to contact him back. But he asked to make an oral argument on behalf of this motion to intervene. I think that's okay. And if there are any objections, we'll hear them afterwards. Mr. Langseth, are you ready?
I am ready, sir.
I think it's okay. Please sit down.
Name is Richard Langseth, Budlong Farm Road in Warwick. And I filed a motion to intervene as a matter of right. And the reason is we, in January of 2023, had a meeting and the other side of my case was here, the Buttonwood Beach Association. And Mr. DeSisto suggested that our case was relevant or similar to the Spring Avenue case, and that it would be a good idea to hear the Spring Avenue situation first, because there were professional lawyers on both sides, and they could argue the case and come to conclusions that would be helpful to my case. So I said, fine, that makes sense. The other side agreed, and we went into abeyance. Then that following October 27th, there was a meeting here, and everything was supposed to be done by December 15th. The schedule was supposed to be agreed to. All the facts were going to be presented, and then the Attorney General suggested that he didn't have enough time and that he wanted an extension. And then the Wheaton Park Fire District came up with the fact that only one person had been testified, and that they had 24 more that they wanted to pose. And so everything went according to schedule. I mean, you folks agreed. And then after the vote, then I stood up as a member of the public, and I suggested that you should limit the number of people being deposed, because I was sitting there waiting behind these folks, and if they depose 25, fine, but what happens if they depose 50 or 100? I was concerned that my case would be delayed. So I just mentioned that. I just said, hey, could you guys, try to limit the number of people, the number of witnesses? So that was okay. I mean, it was just public comment. Then 3 days later, I got a letter from Lock Ward, from Mr. Farside, who suggested that he wanted to depose me. And at that point, I felt that my suggestion 3 days before was what caused him to write a letter 3 days afterwards. And that he was deposing me sort of to either control me or to cause trouble. And so therefore I contacted the ACLU. And the ACLU looked at the case and they came back and they suggested that Mr. Farside take back the letter. He never did. The letter is still outstanding, although in his brief on this motion, he said that I'm not going to be deposed. If that were the case, why didn't he come back and you know, withdraw his motion? So he didn't. And then things dragged on through the spring, and I was getting more and more concerned. So I felt in a timely way, which I think it was, I filed a motion to intervene as a matter of right. I think it's important that the people before the CRMC subcommittee are treated with dignity, respect, and we all know that you have limited resources, and we all know that I was first. And we all know that they came in, and we all know that they do have some motions that might be interesting, and there may be some conclusions of law that would help me. But that's not the point. The point is that I have a right, because I've been here since 2002 with my motion, and to have people come in and attempt to intimidate me is not correct. So that's the basis of it. Now, what I'd like to do is maybe come back after they present their objection. But what I want to do is I want to cite a case, US versus El Paso Gas, which was on the Superior Court 24A2, which is a federal motion, a federal rule of procedure, and in the US Supreme Court, they heard a similar matter, El Paso Gas, where there was another gas company that felt that procedurally things weren't working out correctly. And so what the US Supreme Court did was they said, on these 24-2A Bs, not A's, but Bs, one can move ahead with procedural intervention. And you know, I got a lot, but I don't want to waste everybody's time. So anyway, that's the situation.
Okay,
There is an objection on the matter. Mr. Farside?
Thank you, Mr. Nasisto. Good evening to the subcommittee. Good evening, Mr. Langseth. I'll be brief. We sent the letter we sent to Mr. Langseth in connection with his role as I recall, a donor to a GoFundMe effort, not for any intimidation tactics. I take issue with that. Mr. Langseth need not to intervene in order to represent the public here. The public is already more than adequately represented by intervener Contrada, her counsel, Mr. Rubin, and the Attorney General's office. We've conducted between all the parties dozens of depositions at this point and a lot of other procedural necessities. So for those reasons, allowing an intervener who's a member of the public to intervene now would be unnecessarily duplicative and prejudice the district. I'm just going to be brief on those points and leave it to the subcommittee, but I appreciate your reflecting on our position here.
Would there be any questions for Mr. Farside?
any questions? I've none.
Can I rebut?
You can, yes.
I'm not a member of the public. I was here standing here, not as a member of the public, but representing my case. So this is not a fact-finding intervention. This is a procedural intervention to protect my rights.
Can I ask Mr. Langseth a question?
Absolutely.
Are you concerned that something will happen in this case that will affect your, I'm not going to use the term case, but your petition to have the Buttonwoods right of way be declared a CRMC right of way?
Mostly mortality, sir. You know, I am 81 years old. And this could drag on for years.
So you're seeking to intervene to make sure that the matter moves along?
Right.
Okay. Thank you. Any other questions? Any questions from Mr. Forsythe on this?
No, not from me. Any questions from any of the parties? No?
Thank you very much.
Thank you.
So, Mr. Langseth is seeking to intervene in this case because his concerns as to the how long it is taking for the matter to move forward. And it seems to me that's why he's seeking to intervene. He's mentioned that he's not getting any younger, and that's why he wants to intervene in this case to ensure a timely disposition of the matter. So the question is whether you're going to grant his motion to intervene or deny it.
Is there legal support for it? Not an assertion that he's not getting any younger, because we're not, but I don't know if that's legal grounds.
You know, I had a full head of black hair before becoming on the CRMC lawyer. But, you know, to me, the standard to intervene on this, Mr. Forsythe can correct me if I'm wrong, is if you have some interest in the particular subject matter that is not being adequately represented. Mr. Langseth is coming in on a procedural issue. He will not be precluded from participating as a member of the public on this. But his main concern has to do with another right of way on this, which is different from the subject matter of this petition.
Any questions from the subcommittee members of Attorney DeSisto?
Yes, could you explain that a little bit more? His position is related to another right of way?
Yes, I don't know if you remember way back when, but when this matter went forward, Mr. Langseth said, hey, you know, I've been pressing on this Buttonwoods right of way for some time now. And the statement was made at the time, was by me, that once this matter wrapped up, the subcommittee would take up the Buttonwoods right of way. That was a long time ago. And that's why he's seeking to intervene now. He's saying, look, I want to get going on this. I've been waiting a long time. I don't think either he or I anticipated that it was going to take this long for this one to go ahead. That's why he's seeking to intervene. He just wants it to keep moving along, rather than saying I have a particularized interest in this right of way that's different from the public. So that's where he's coming from.
How will it play out if we allow him to intervene to move this along? How does that work?
I'm not so sure that based on where we are on this thing, that there's going to be an effect on it. Once these motions get done on it and the discovery is completed, then I think it can go to hearing, but you're looking at some months, depending on what happens here. Procedurally, it's where it is. Meaning to say, I'm not too sure that they can be in effect to move it along any faster than it's going.
Okay, and the testimony so far is that that's the sole reason that he feels it necessary to become an intervener.
Correct, yes. In other words, procedural, it's not subject matter, it's procedural.
Right.
And that would give him an opportunity to object if there were more motions filed, if there were other discovery requests prior to the hearing. I think that's what the import of this is.
Okay. Any questions? So at this point, we have a motion to intervene and an objection to that motion, correct?
Yeah, and the action for the subcommittee would be either to grant the motion and allow Mr. Langseth to intervene or to deny his motion.
Okay, we don't need to rule on the objection.
No,
We basically would be
yes,
with the first decision. Okay. Is the subcommittee in a posture to make a motion on this?
I can make a motion. I think Mr. Langseth raises a legitimate concern we all share, but it doesn't seem that it arises to a legal standard to be an intervener, so I would move that we deny the request for intervention.
Is there a second?
I'll second that.
The motion has been made and seconded to deny the motion to intervene. Is there any discussion? Hearing none, I'll pull the subcommittee. Mr. Gagnon,
Yes,
Ms. Reynolds?
Yes.
I too, Ray McCoy vote aye. Pretty much for the reasons set forth by Mr. Gagnon on the legal support for it.
So could I hear I couldn't quite hear the final vote.
it's 3-1 to deny the motion to intervene.
3-0.
3-0. 3-0.
3-0.
3-0.
Three to deny.
3-0. This does not mean you can't participate as a member of the public, just not as a party to the matter. I'm going to make a suggestion to the subcommittee at this time. Mr. Farside, on behalf of his client, and Mr. Legori, have several motions. I would recommend that you take up the Weekapaug Fire District motions first. And then you can take up the motions for Caroline Contrada. And then the Attorney General's motions afterwards. I think that's probably the best way to go about this. And if you take a look at the posted agenda, the motions are based on the time that they were filed. That would mean that the first motion to be taken up would be the motion to issue a subpoena to Matthew Ferraro. If that's acceptable to the subcommittee.
That's fine.
Thank you again, Mr. Sisto, and to the honorable subcommittee. We have here an individual, Matthew Ferraro, who was set forth and disclosed as a fact witness by Ms. Contrada, an intervener in this case, back on September 22nd, 2023, so over a year ago. A couple of the witnesses we've deposed have signaled Mr. Ferraro as the source of not only some information about Spring Avenue Extension, but the actual impetus for why they came forward to testify. During the course of cooperation with Attorney Rubin over the deposition scheduling of various witnesses, Mr. Rubin notified us that they were withdrawing Mr. Ferraro as a witness that they had disclosed, and that they would not be making him available voluntarily to sit for a deposition with us. Now, just for context, and this applies to other motions, we've been through a number of depositions with each other, depositions of each other's witnesses, handled these all professionally and cooperatively, and even picking locations that were convenient to certain witnesses, maybe when it was inconvenient to the attorneys. We would like to depose Mr. Ferraro to find out what he knows and further probe his willingness to cause others to come forward and sit for depositions. He, according to certain of these witnesses, has information about Spring Avenue Extension. So for those reasons, we're requesting that the subcommittee issue a subpoena to Mr. Ferraro so that we can report to him.
Are there any questions from Mr. Farside before we hear the objection?
Yeah, and Mr. DeSisto, Caroline Contrada, represented by me, did not object. I did not object. So we have no problem with taking, having a subpoena testify, have Mr. Ferraro testify. I mean, he was originally named as a witness by us, and I understand that they want to depose him. And we don't control Mr. Ferraro. He's his own person. He's not my client, so I can't just produce him. But if a subpoena is issued, we'll obviously do everything we can to facilitate that. But I did want to comment on one part of the motion, which is that he would produce any relevant information. I don't want any person who happens to have knowledge relevant to a CRMC proceeding to be burdened to go hither and yon looking for things that they might have at one time seen. I mean, if he has actual correspondence that bear in his possession that bear upon this matter, fine. So it's just the documents part that raises concerns, because maybe Mr. Farsight's definition of relevant information and my definition of relevant information don't coincide. So I'm just concerned about subpoena having a duces tecum component, which would be a request to produce documents component, and that would be overbroad. So if that was narrowly focused on things that were in his immediate possession, and he didn't have to go and try to track things down, or remember, or produce something that maybe he remembers but doesn't have in his possession, I'm fine with it. Otherwise, people are not going to want to come forward and help the CRMC designate rights away.
May I ask a question for Mr. Forsythe?
Sure.
Is the evidence going to be duplicative? Or do you feel that, or do you assert that this particular witness has additional evidence that you will go beyond what you have already obtained in your depositions?
Well, we don't know what we don't know. And I think that the risk of a person here who has expressed that he has knowledge to others and has been the impetus for others coming forward, it's a risk that he shows up to testify live at the hearing in this matter with information that we didn't take steps to discover when we could have discovered it. So all because he was withdrawn from the witness list of intervener Contrada. So these depositions are typically not long experiences. They've been whittled down to an hour's time and 2 hours time at most. And we have a directive to go investigate this matter. The other side has produced certain witnesses that claim to have knowledge of the existence of a supposed path, and this is one of those people who's out there. So we think it's our obligation to track him down and find out what he knows.
Next question. Is it your claim that this subcommittee can issue a subpoena?
Yes, it is. And that's under 4623-20.6.
Do you mind if I want to make sure that what we're doing here isn't something that would be subject to a appeal later on. I'm looking at 20.6 now. And I see that the executive director can issue a subpoena. And I also see that the hearing officer can issue a subpoena. I just want to make sure that the subcommittee can do that too, under the can do the same. Council is mentioned also. I just want to make sure that this is something that you're comfortable with the subcommittee being able to do that too.
Well, the correct procedural approach might be for the subcommittee to direct the executive director to issue it.
Thank you.
I just clarify my position is that if the witness says that maybe once they might have seen a map someplace, and maybe they think they might have seen a map, they're not really sure. I don't want that witness to go and have to then track that map down. Like maybe they saw a map their father's house or their mother's house, their parents' house. I don't want, you know, and if the witness is vague and indefinite, but if the witness has something in his immediate control, I have no problem required to produce that. But I don't want the witness to have to go on a scavenger hunt based on faint, uncertain and attenuated memories.
We will not seek to have the witness produce things not in the witness's possession.
Does the subcommittee need to hear any more on this particular motion?
I do not. Do you? No, okay,
There's no objection. The evidence may not be something that is necessary for the council, but one never knows. I think that Mr. Forsythe has a good suggestion that if the motion is to grant this motion, that the executive director be directed to issue the subpoena.
so the motion would be
If it's to grant,
to grant and ask or direct, whatever the proper term is, our executive director to issue the subpoena.
correct.
Okay.
Should there be some stipulation added about the reasonability of what types of documents need to be produced?
No, and I'm gonna tell you why. If the witness doesn't have it and the claim is that they're withholding evidence, they'd have to come back here for that, so you'd get another crack at it.
Okay. Are we in a posture for a motion?
Yeah, I think you are, yeah.
All right,
Okay, I'll make a motion that we grant the motion and ask the executive director to issue the subpoena.
Second.
motion made and seconded, any discussion? None. Ms. Reynolds,
Aye.
Mr. Gagnon,
Aye.
I too, Ray McCoy, vote aye on the motion.
Okay, the next one is the motion to issue the subpoena to save the bay.
That's right, and my co-counsel, Mr. Legori, will argue that on behalf of the fire district.
I'm sorry, go ahead.
The chair was still writing.
Thank you.
Make sure he
Thank
had
you.
a chance to finish. Thomas Legori on behalf of the Newport Fire District. C. Right, and this body. Director, executive director, to issue a subpoena to save the bay. Save the Bay first became involved in this matter, to our knowledge, on November 17th, 2021, when it submitted comments to the CRMC with respect to this matter. At the outset, it said, Save the Bay submits this letter in support of declaring that the Spring Avenue extension is a public right-of-way. Then it asserted certain facts. For generations, this access point has been used by fishermen, beachgoers, and other recreational users in the Weekabuck section of Westwood. Many of Save the Bay's members and supporters have used this right-of-way for decades to directly access nearly 2 miles of sandy shoreline bordering the Atlantic Ocean. And then it went on with more factual assertions. Over the years, the access point has been restricted and overgrown with vegetation, thus eliminating access to the public. On January 12th, 22, Save the Bay submitted a revised comment to CRMC. The revised comment simply deleted all of this paragraph except for its introductory sentence. On October 3rd, 2023, I, as counsel for the Weekabuck Fire District, wrote to Save the Bay, setting forth 8 bullet points requesting information. The first 4 are: The identities of the quote fishermen, beachgoers, and other recreation users in the Weekabog section of Wesley, Rhode Island. And quote, including quote, many of Save the Bay's members and supporters, and quote, who Save the Bay claims used this right of way for decades to directly access the nearly 2 miles of sandy shore bordering the Atlantic Ocean, end quote. The times, months and years during which those individuals have used the SAE to gain access to the shoreline. The basis for Save the Bay statement that over the years, this access point has been restricted and overgrown with vegetation, thus eliminating access for the public, including the basis for its belief the public's access has been eliminated. Fourth, basis for the revision of STP's November 17 comment letter as identified in the enclosed red line, including but not limited to the omission of all reference to fishermen, beachgoers, and other recreational users of the SAE, including Save the Bay members and supporters, and the omission of reference to SAE becoming restricted and overgrown with vegetation. Save the Bay simply responded by email with regard to the bulleted statements of in that letter. The first four bullets that I referenced, it responded. Save the Bay, with regard to bulleted statements in your letter, bullets 1 through 4, we made a mistake in our original letter and sent a corrected revised matter. Town of Wesley now objects to the subpoena request, saying Save the Bay did respond, drew into the Weekabog Fire District what it knew. A mistake was made and it was corrected. Save the Bay said the information was in error, so therefore no more information exists. For starters, what mistake? That's a relevant inquiry beyond anything yet, right at the outset. We made a mistake. Did did Save the Bay become aware of facts which disproved its assertions? For example, has it learned that for generations, SAE access point has not been used by fishermen, beachgoers, and other recreational users? Should have an opportunity to address that in a deposition before hearing in which they might raise that and we have to are left with a gap. Or has it learned that many of its members and supporters have not used the SAE for decades to directly access the nearly 2 miles of sandy shoreline bordering the Atlantic Ocean? The movement on behalf of Mr. Trotter, objection states. Weekabog Fire District seeks to turn the focus of this case away from the lot of land at issue. The subpoena is directed principally and precisely to the lot in land at issue. Save the Bay made succinct statements with respect to use of this property. It then said it made a mistake. Which is it? Clearly, Save the Bay professes knowledge of facts related to this property. This is the critical issue in the matter. It is not extraneous. The Attorney General objects to the requested subpoena also. Of particular interest is the fact that the memorandum in support of his motion to intervene is almost a verbatim copy of the factual assertions Save the Bay stated initially and then withdrew before the Attorney General's intervention using the same language. Save the Bay's initial denial of any further information stated, for generations, this access point has been used by beachgoers, fishermen, and other community members, a tradition that has recently been blocked by abutters and other interested parties. Compare that to the Attorney General's petition. For generations, this access point has been used by fishermen, beachgoers, and recreational users over the years. This access point has been restricted and overgrown with vegetation, thus eliminating access to the public. A deposition is especially warranted as to the facts known by Save the Bay. I also want to further comment just briefly. This isn't a lay entity wandering into into this proceeding. This is a public figure. They are, Save the Bay is akin to a public figure that has thrust itself into the forefront of particular public controversies in order to influence the resolution of these issues. Law School 101, Sullivan versus New York Times, and its progeny, including cases decided by the District Court of Rhode Island, Federal District Court. They're not some innocent granny. Additionally, Save the Bay has contributed financially to the intervener for a title search and asserts a common interest privilege as if it were a party. And happy to answer questions or respond as the fellow counsel.
Any questions of Attorney Legori?
For the objectors, who's gonna go first? Ms. O'Toole?
Yes, my name is Sarah O'Toole. I represent the town of Westerly. We vehemently object to this petition, not because we have any personal knowledge of what the Save the Bay may or may not know, but because if you look at the pleadings and the filings which were submitted in this memorandum, it clearly shows that Save the Bay doesn't know anything. We, of course, would love it if more people came forward and wanted to participate with relevant information. However, Save the Bay specifically said they made a mistake. They retracted their letter, which said they had names or individuals who were willing to come forward. And that letter specifically states that the only thing they have is legal theories, which of course everybody has. This motion, in the town's point of view, is just another motion that's just being filed to intimidate people to not come forward in this case. I'll just be very brief because everything was outlined in my motion, and I understand that the members of the subcommittee have read it. However, there's been a trend of letters going out, one of which was sent to Mr. Langsa, that said, we want to depose you simply because you donated to Caroline Contrada's GoFundMe. Just because Save the Bay sent a letter in support of Spring Avenue Extension being designated as a right-of-way, retracted that letter, changed it, and then made a donation to expert witness fees, doesn't mean they have any relevant information that's worthy of taking the time to be deposed.
Yes, if I could join in, I think that Mr. Legori did an able job, and he quoted my memorandum, or my objection rather, and I think he did a fair job. I think this diverts this committee's attention from the piece of land at issue to a secondary matter, which is who is behind the interest in this matter, which might be something that's very interesting to Mr. Legori's client, to Mr. Legori, and maybe it should be explored in some forum, but this is about a piece of land. People have been fighting over land since the time of Hammurabi. It's like no big thing. It's people fight over land all the time. And that's what it is. It's about this piece of land. And I think in my, Mr. Legori didn't quote it, but I think in my objection, I quoted Mr. Farside at an earlier appearance before this council saying, this is just a real estate dispute over a piece of land. So why are we getting into these secondary issues of who's backing whom, who's financing whom, who's donating what? And why are we looking at what is essentially a neutral position on Save the Bay as to whether there are witnesses? Save the Bay first said, yes, there are witnesses. Then they said, no, we made a mistake. We don't have any witnesses. They didn't say we have witnesses who say that they didn't use it or that there was no path. They just said, that was an overstatement. We should not have said that. and we don't have any information one way or the other as to whether there's witnesses on one side or the other. But Save the Bay did maintain its legal position, which is basically that there was a statutory dedication. And that's a legal position that they're free to take, and it's a legal position that this, committee, the subcommittee is going to make its own independent judgment on. They're not a party, they're just a member of the public comment. So I really don't see where this is going, and what are you going to do? Probe their legal position? What case did you look at? What statute did you look at? I mean, it really gets into the thought processes of whoever the Save the Bay attorney might have been. So there really is a dead end here, and I really think it's a diversion of resources away from the piece of land to Spring Avenue extension. Thank you.
Mr. Schultz?
Yeah, good evening, Mr. Chair, members of the subcommittee. Gregory Schultz, Special Assistant Attorney General. The Attorney General just joins with the two objectors, the town and Ms. Contrada. Thank you.
I have a question. And I just don't understand, make sure my understanding of what's been argued is correct. Save the Bay came forth and said, we have some information. Then they said, no, we were mistaken. We don't have any information pertinent. And to date, has anyone been able to ask them any questions? And I know I kind of got a feeling that's what we're here for. They want to subpoena them and ask them questions about the assertion we have it, then the retraction, no, we don't. Is that, am I correct? Like, that's what's out there?
I think that's the basis for requesting a subpoena.
Okay.
Could I ask a question about that too? So when a subpoena is issued to an organization, does it go to a specific individual? Was there a signature on that letter that that specific person gets subpoenaed? Because organizations change over time and
I'm going to guess, but I'll ask Mr. Liguori that this would be what's known as a keeper of records subpoena. And the request would be a subpoena ducus tecum, which means bring along records. And whoever keeps the records for Save the Bay would be required to furnish them either at a deposition or beforehand for any relevant information. I can't say that because I don't know, but I'm going to ask.
The letters, initial letter, the retraction letter were both executed by the interim executive director at the time of Save the Bay, who is now the executive director of Save the Bay. Ropa Hamlet. When you would ask, that would be issued to him as a fact, on the basis of fact, and would speak to the state.
Any further questions?
So to clarify, if there was a subpoena, it'd just be for a subpoena for any records that they might have in relation to.
No, Mr. Liguori would actually direct it towards the executive director of Save the Bay. And the question is, does Save the Bay have any relevant information? Since the basis is a letter that was sent and then at least partially retracted. So here's the way that I think you need to look at all of these motions coming in. Are they designed to produce evidence that will be relevant to a decision as to whether or not the Spring Avenue extension should be designated as a right of way to the shore of the state of Rhode Island? So that's the question. Based on what you heard, is this something that will get relevant information to what you need to decide? And Mr. Liguori says yes. The objectors are saying no, just based on the letters.
If we look at the letter at the outset, it asserts, for generations, this access point has been used by fishermen, beachgoers, and other recreational users in the Week Book section of Westerly, Rhode Island. We don't know that after this withdrawal, what facts they did have.
Yeah.
They might have withdrawn this because they found facts that said for generations, this access point has not been used. That's the ultimate, one of the real issues in this matter is how has it been or has it not been used over many generations?
Could you also read the response that you had? What did they say specifically about that they've changed their mind or they had different information or?
With regard to the bulleted statement in your letter. Bullets 1 through 4, we made a mistake in our initial letter and sent a corrected revised letter. All it did is withdraw the paragraph in its entirety, except for saying we want to bring this to CRMC's attention. We don't know which of the statements now they found to be true and which they found to be false. And that's all we need is the opportunity to ask those questions.
If I may, I don't think that there's any implication they found statements to be false. They just found that they didn't have sufficient information to make any statement. I think if you read the second letter, that's basically what it said. We just don't know. You know, and if they don't know, what are you gonna do? Put them under oath to say we don't know? That really constitutes a kind of harassment that Ms. O'Toole referred to.
Saying they don't know.
All right, guys, hold on. This isn't, you're not dealing with the judge that hears these on a regular basis. This is a lay board. Let's slow it down. You've made your arguments. Are there any other questions?
Not for me. Any questions?
So if they retracted that information, they can't come back during a hearing and say, oh, we changed our mind again, we have information.
Well, that goes to credibility. Because they made a statement and they said that, we have to take the statement back. So, in the public portion of it, are they gonna come back later on and say, now we have further information? And that's the question. I think what Mr. Liguori is saying here is that they made the statement and then they took the statement back. Why is that? Do they have relevant information? I think that's what he's trying to say. I think the question for the subcommittee is it relevant as to what Save the Bay knew or didn't know in the determination as to whether or not this is a right of way? Save the Bay is an advocacy group. It's a non-government organization.
And we don't know that from what's before us. And I think that's what the attorney is trying to find out from them. Okay. So we have here the motion to, yep, so we have before us a motion to subpoena Save the Bay for a deposition.
That's correct. And specifically, the executive director of Save the Bay. And I'm assuming that's limited to the knowledge that's contained in the 2 letters.
Okay, is there a motion from the subcommittee?
I guess if we wanted to err on the side of caution, it'd be best to move that we ask the executive director to issue the subpoena to Save the Bay for deposition.
For a second? Can I second it?
If you can, yes.
I will second it. Motion been made and seconded. Any discussion? Hold the subcommittee, Mr. Gagnon,
Yes.
Ms. Reynolds,
No, I feel there's nothing new to be learned.
I vote aye. Motion's granted.
Thank you.
Well,
Did we hear that? We had trouble hearing the vote.
2-1. Motion to grant. Okay, next up is the motion to subpoena the Saltwater Anglers Association.
Thank you, Mr. DeSisto. Joe Farside again for the Weekapaug Fire District. Saltwater anglers are similarly positioned insofar as they sent a letter dated November 30th, 2022 to CRMC to the attention of Mr. Willis. In support of Spring Avenue Extension being made or designated as a public right of way. We sent a letter in September of 2023. Actually, that related to a letter among the RISA, that's Rhode Island Saltwater Anglers Association membership, about a group of volunteers working to open the right of way at Spring Avenue and Weekapaug. They say, due to unforeseen personal circumstances, a key witness who recalls vital details about the right of way may not be able to participate. The loss of this right of way may very well result in the loss of shoreline fishing access to this almost 2-mile stretch of pristine barrier beach. Our letter to RISA reminded them that fishermen have access to that stretch of beach, except for during summer beach hours of approximately 9 a.m. to 5 p.m. from mid-June to mid-September, which, by the way, are not prime fishing hours, and asked for a response. And we even sent a follow-up letter asking for a response and the basis for some of the claims in their letters, and never received anything. So we are now here looking for a subpoena to depose and find out what the Saltwater Anglers Association, what information they may possess with respect to Spring Avenue Extension. Thank you.
Thank you.
If I may, my client Caroline Contrada objected. Number one, there's several letters that we're talking about here, and I don't know if that was made clear. In the letter that the anglers wrote to the committee or to this to the CRMC, no evidence was offered. They didn't make, as far as I know, and maybe I'm forgetting, but there was no statement like was made in the initial Save the Bay statement that yes, we have members and they have these particular that. And so there was no assertion of fact, unlike the situation that you dealt with a few moments ago. It was just a statement of opinion from a citizen or a citizens advocacy group to a governmental entity. And this governmental entity, as I don't have to tell you, is not purely adjudicatory. You have legislative functions, adjudicative functions, executive functions. And you combine functions. And if we're going to start saying citizens can't contact their representatives in government without enduring a subpoena, I think we're on pretty scary territory. The other communications that Mr. Farside is referring to was communications from RISA, Rhode Island Saltwater Anglers, to its own members, soliciting members to come forward if they have knowledge. Not saying that they did have knowledge, soliciting, would you come forward if you have knowledge? And then indicating that what was at stake here. And, now is not the time or place to argue the merits of this case, but the access that Mr. Farside refers to. This is sort of an aside, but Mr. Farside went there, so I have to too. The access that he refers to is permissive access. It can be withdrawn anytime. It can be withdrawn tonight or tomorrow morning. So that's permissive access. It's not access as a right, is what we're fighting for here. So I really think that this doesn't even have the strength that the prior motion had for the Save the Bay. and then it really is, more or less, intimidation and chilling. Now, if RISA comes up with a witness that they refer to me and I listened to that witness with the intent to have that witness testify, well, of course, they should be able to impose that witness.
The town joins with Attorney Rubin on this. Again, we are of the opinion that these depositions are veering into mere speculation. There's no basis to have any of these depositions. RISA, again, has not put forth any sort of names or affirmative statements that they had any members that actually use the Spring Avenue extension. And some of the letters just appear as if it was bolstering as well. Thank you.
I have a question of Attorney Rubin, please. You used the term that you felt it was intimidating for them to ask. How do you find it to be intimidating for them to ask to depose a person?
Well, I think that when they don't even purport to have knowledge, specific knowledge, and they're just soliciting that knowledge, I kind of find it onerous if I voice an opinion and then I have to perhaps hire a lawyer, perhaps, take off from work, perhaps travel to a place to have a deposition.
Or there's two different definitions of onerous and intimidation.
Yeah.
So I don't know if maybe you didn't mean intimidation as people traditionally use the word to intimidate. I don't know, that's why I'm asking.
Well, it seems to have a chilling effect on people coming forward to a forum that was designed, I think, to be hospitable for ordinary citizens.
Mhm.
And in partial response, Chairman Koya, we're defending an attempt to have our real estate essentially taken from our clients. So we find it to be our obligation to investigate when somebody states that a key witness recalls vital details about a right-of-way, that we investigate that before that person shows up at the final hearing of this matter. I take issue with the use of the word intimidation regarding depositions, which are an everyday tactic used in litigation.
Attorney Schultz?
And, good evening again, Gregory Schultz from the Attorney General. The Attorney General joins also these objections. I would like to point out, with regards to whether onerous as opposed to intimidating, as the subcommittee may know, the ACLU did issue a letter with regards to letters that the fire district did send out to them. So there are some people, I think, that would feel that these letters were in fact intimidation. Thank you.
We're not speaking here about those letters. This is a request for a subpoena to RISA.
So the difference between this communication and the other communications, the one from Save the Bay presented a question of fact. What did they know and why did they retract it? Is there a basis for that? The Saltwater Anglers, they're an advocacy group too. I think if you take a look at it, the assertions here are not the same as the ones prior to it. And I'm going to tell you, I just don't think you're looking at something here that is going to obtain relevant information at this time. I'm sure members of the Saltwater Anglers Association will probably speak when we get to the public portion of it. But on this, taking a look at the letter, can you really say that the association itself has some information? I don't know that you could say that here, and I wanted to draw the distinction between this one and the prior correspondence, which was two.
Thanks. Any questions? Mr. Gagnon or Ms. Reynolds? For motion.
I'd make the motion that we deny the request for a subpoena based on the Rhode Island Saltwater Anglers, let it be more a statement of opinion. And they don't have any relevant information to offer.
Is there a second?
I'll second that.
Motion made and seconded to deny the request. I'll now poll the subcommittee, Mr. Gagnon,
Yes.
Ms. Reynolds,
Yes, finding the objector's arguments persuasive.
I too vote aye.
The next motion up is to strike an expert report authored by Attorney Justin T. Shea, which was proffered by the town of Westerly. The motion is to strike the expert report.
Thank you, Mr. Sisto and Subcommittee Joe Forsythe again for the fire district. The legal standard under the Rhode Island Rules of Evidence for testimony, to allow testimony by an expert is, and I quote, if scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or determine a fact and issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of fact or opinion. So the witness, there are three prongs there. The witness must bring technical, scientific, or other specialized knowledge. The witness must be qualified by virtue of knowledge, skill, experience, training. And third, the witness proffered testimony must be helpful to the trier of fact, which here is the subcommittee. The main issue with Mr. Shea is not his education or experience, because he's an extraordinarily well-respected member of the bar. The issue is that his proposed testimony does not go to a question of fact. It goes to the ultimate legal conclusion based on facts in this matter. In other words, his report is exclusively legal conclusions and interpretations of case law, and not a report with opinions that do not go to the ultimate legal conclusion here. The ultimate legal conclusion that Mr. Shea advocates is that the Spring Avenue extension is a public right of way for various legal land title related issues. I realize that we're before an administrative body here and not before a jury in a superior court. However, the rules of evidence must mean something, and the parties have agreed to abide by them. And the report cannot come in as it is with pure legal conclusions. It has to instead aid the trier of fact in reaching its own legal conclusions. So for those reasons, we have moved to strike Mr. Shea's report. Thank you.
Yes, the town of Westerly has filed an objection to the Weekapaug Fire District's motion to strike. The rules regarding expert witnesses are very different in an administrative tribunal versus in front of a jury. All of the cases which were cited by the fire district in their motion are for jury trials. The difference is because an administrative tribunal under the Administrative Procedures Act, as well as precedents, is considered an expert itself in certain topics. So what can go in front of administrative tribunal tends to be a lot broader than what can be brought in front of a jury. Under the APA, expert opinions must only meet the standards of relevancy, materiality, and non-cumulativeness. As such, tribunals are given wide discretion in weighing evidence and the testimony of expert witnesses. Our state Supreme Court has also described the testimony which can be brought in front of an administrative tribunal by an expert witness as being broader than in front of a jury. And furthermore, the Superior Court rules of Civil Procedure 704 also allow opinions that embrace the ultimate issues. Attorney Shea's expert witness report isn't, as the Weekapaug Fire District claims, exclusively legal opinions. There's review of different deeds, there's review of different maps, there's review of different statutes. Ultimately, the report should be entered and you should weigh its evidence in connection with everything else that's presented by all the parties.
I have nothing to add.
Okay. I have a question of our counsel. If the report is stricken, is there another mode or mechanism for the opinion of Attorney Shea to come in?
Before I answer that, I have a question. In the record, we have an opinion from an attorney, Charles Solovitzik, which was done years ago for the town of Westerly. That's already in. Now, I think what the town of Westerly is doing here, correct me if I'm wrong, is they have another opinion from another attorney on that, which is basically to rebut that. Would that be correct? Now, if we can consider the Solovitzik report, why couldn't we, when I say the subcommittee can consider the Solovitzik report, why couldn't they then consider the Shea report?
Well, the Solovitzik report hasn't been offered here by a party in support of its own position, to my knowledge. And I don't see the Shea report. The Solovitzik report may have been submitted with papers to the subcommittee by advocates. I don't see the Shea report as rebutting or otherwise answering the Solovitzik report. I think the Shea report attempts to advance other theories that Mr. Solovitzik did not advance. And the fact of the matter is the Shea report is the town's expert witness offered in this matter. And, you know, our position is you can't offer a legal brief and claim it to be an expert opinion. And that's what we contend it is.
May I ask another question?
Sure.
And how is that any different than in a quiet title action under section 34-16-2? Part and parcel of an action of that nature is that an attorney furnishes a report to the plaintiff on it, basically saying, look, this is the interest in the land, and these are the conclusions that I have. How is this any different from that?
That would look like a title report, and this is a legal brief. So the title report is going to look at the chain of title and bring.
Sorry.
No problem at all. And bring the facts from the land evidence records, which require some specialized knowledge to review, understand, put in order, make sure you're not missing things. I would certainly miss a lot if I went to do a land evidence record search. And pull that information together in a way that's reliable and it's synthesized. This is not a title report. This is a legal brief that cites cases and addresses different theories of stampings on maps, for example, and then applies case law to that. So this takes several dramatic steps forward to become a legal brief and is not a title report.
Is the claim that Mr. Shea is not an expert in matters of this nature?
No, not necessarily that he's not an expert, no. The claim is that he's opining on the ultimate issue, which is whether legal documents make this a public right of way. And that's an issue that an expert can't opine on. That's an issue that's before subcommittee for decision.
If I may interject, I find myself in the unusual position of agreeing with Mr. Farside on one thing. And that is, I don't believe the Solovitzik report has been offered into evidence or is evidence in this case. And I might be concerned that without Mr. Solovitzik being present, I don't know that anyone's made that arrangement and they would have to arrange to pay him. That and Mr. Solovitzik not being subject to cross-examination, I'm not sure that report would or should come in. Obviously, I guess we can deal with that down the road, but I don't believe that has been offered into evidence like this report would be. I would like to point out that there is another title expert in this case, in addition to Mr. Shea, and that's Joseph A. Priestley. And Joseph A. Priestley is being offered by Caroline Contrada. There is a motion that concerns Mr. Priestley, but it doesn't go to the admissibility of the report, as I understand it.
I really don't have too much more to add than what was already argued, other than what's already in my, brief, which was submitted to this tribunal, for review. But however, I will reiterate the standards for what can be brought in front of an administrative tribunal are very broad, and an expert is certainly allowed to give opinions as to legal conclusions, as long as it's backed up by foundational evidence, all of which were included in Attorney Shea's report. And furthermore, if this goes forward to a hearing and Attorney Shea is brought in for questioning, this tribunal will have the ability to weigh all of the evidence and weigh all of the testimony.
So going back, I'm not sure if you answered my question.
I didn't.
Because I know you said let you ask a question first. If this, let me ask you this way, if this comes in, someone's got the right to cross-examine him or question him on his report, correct?
That's correct, yes.
Okay. If it doesn't come in, someone can bring him in live and put him as a witness before us, correct?
Yes, I think the key word that you heard was actually right at the end. And it goes to the weight of the evidence. And of course, you know, I'm big on weight. But in this circumstance, this has been proffered. I understand what Mr. Farside is saying on this thing. But the report has been submitted, and it is something that will have to be considered. And I'm assuming at some point there's going to be legal arguments on both sides. In this instance, the town of Westerly is leading with what their arguments are going to be. And that means the Weekapaug Fire District pretty much already knows what Mr. Shea is going to say. I'm sure that'll be counted later on. And he can be cross-examined too on his expert opinion.
Okay. Thank you. Any questions from Mr. Gagnon or Ms. Reynolds?
Is the statement about different standards for administrative procedure versus a trial? Are they different standards?
Those statements apply across the board.
I mean,
That means yes. You know, would this be happening in what's happening here? Would this be happening in Superior Court? Probably not. But this isn't Superior Court. This is a subcommittee of a state agency.
Is there a motion from the subcommittee?
I would make a motion not to strike the expert report prepared by Justin T. Shea.
So the motion should be to deny the motion to strike.
Okay. I would like to make a motion to deny the motion to strike the expert report.
Second.
Motion has been made and seconded to deny the request to strike the report. Any discussion? And then I'll poll the subcommittee. Mr. Gagnon, Ms. Reynolds.
I
Too vote aye.
So the next motion is to disqualify Ms. Kornakia as an expert and to strike her expert report offered by the intervener, Caroline Contrato.
Mr. DeSisto and subcommittee, and I should offer my thanks for your thoughtful consideration of these motions in a timely manner tonight. Ms. Kornakia presents another instance of an expert witness who's being attempted to be used to do more than she's qualified to do. I submit that this is a more stark set of circumstances than the circumstance that we just described with Mr. Shea. Ms. Kornakia, it purports to be qualified as an archivist. An archivist is someone who specializes in preserving original records, handling records, and helping people obtain records. In other words, somebody who's got the knowledge of how information is stored, the locations where it might be stored, how to access it in an orderly fashion. What Ms. Kornakia has done here, or what Ms. Contrada has offered Ms. Kornakia to do, is to collect really reams of paperwork from various sources, none of which requires an archivist training to obtain. To pull those documents together, to make her own, in a lot of cases, to make her own markings on those documents, and to then submit those documents with her markings on them, sometimes with a whole narrative across the top or the bottom about what the image or map purports to be. Sometimes maps with color coding on them, sometimes maps with colored outlines that she superimposed. And she's offered, as a way to sort of backdoor this so-called evidence into the subcommittee in this hearing process, so that Ms. Contrada or the town or the Attorney General's office would not need to go out and find or utilize human beings to authenticate these documents, explain what they are and where they came from. So by analogy, I sat through 5 hours of a trial today in which I represent the client as a defendant, and we have to be very careful about laying the foundation for the existence of documents, the location from where documents came. We have to convince the judge that the documents are authentic, that they haven't been changed or altered, and if they have been altered, how they've been altered. And again, I realize we're not in a court of law here, but we are before a quasi-judicial agency that needs to have some standards in terms of being a gatekeeper for the evidence that's put before it. Now, Ms. Kornakia, and I apologize for mixing their names up more than just tonight, has offered, I think, 8 to 10 different packets that purport to have a sequence of documents, again, with her markings and color codings on them. We're moving to disqualify all of them and move to strike the entirety of her report. Other examples are documents with highlighting on them, documents with maps and figures with arrows to point at things that she finds interesting. I think the final point that I'll make is it's axiomatic that an expert, somebody who's been put forth as an expert, be independent and impartial, at least on the surface. Ms. Kornakia has been an outspoken advocate for shoreline activist views and issues and efforts for a long time. In fact, I think we've counted over 100 social media posts where she's advocating for shoreline access, mainly in the westerly area, but also criticizing fire districts. And her bias removes any veneer that she might be an impartial expert setting forth her opinions in an impartial way. So the combination of her alteration of documents that she located ad nauseum and her bias as a shoreline activist and somebody who's against fire districts should all result in her so-called expert reports being stricken. Thank you.
Ms. Carnaccia is, or was, the chief records manager for the Naval War College. She is incredibly credentialed. And it's not just a question of being an archivist, it's also a question of being a records manager, which is part of library science. Where do I begin? There are, for one thing, there are some issues in this case that are records management issues. For instance, the Weekapaug Fire District claims, I don't doubt those, that their headquarters and essentially all of its files were destroyed in a fire in year 2015, I believe, it might have been 2016. There are certain issues that arise there, like what are they supposed to do in that case as a government entity that's subject to the Secretary of State and the APRA requirements. That a records manager knows, what to do, what to preserve, what to report in the case of a disaster like that wipes out the record. Another instance, and this arose fairly early on in this case, where there were certain stamps on a certain plat that reflect the approval of the zoning board of the town of Westerly and what was then called the Highway Commission of the town of Westerly. It's now the DPW. And minutes were sought by Mr. Liguri, who we heard from some time ago here tonight. And the clerk indicated that there were no such minutes going back to 1939, which is when these stampings take place. Ms. Carnaccia has knowledge and expertise about the absence of a record and how you reconstruct things in the absence of a record and how you establish the absence of a record. And who is it that is entrusted with establishing the absence of a record and the significance of the absence of a record? Does it mean that the record never existed? Does it mean that it existed, but it somehow got lost? She has methods and a methodology for dealing with these questions. So that's just one small part of my objection. The larger issue, though, here is twofold. Number one, it's premature. We're talking about a witness that has assiduously produced 13 reports. They form a book in essence. I think that there are a lot of things in these reports that any layperson could testify to. I went to town hall. I asked the clerk where certain kinds of maps were. She pointed me to the maps. Here's a picture of the map that I saw there. I don't know that you need an expert to testify to that one way or another. Now, there are also dating, that is establishing a date for certain critical photographs. Now, it just so happens, and I credit Weekapaug Fire District for being forthcoming in discovery, and they supplemented the discovery by providing a certain photograph that was of great interest, a photograph that I believe was taken in the 1940s. Although I think one witness testified, I think a seat of the pants testimony, that it might have been the 1930s. So it matters what the date is of that photograph. So I propounded interrogatories to them, and Mr. McMahon, their moderator, or then their moderator, which is essentially a president, responded that based on the presence of a certain yacht club that was depicted in the picture, which yacht club was wiped out by the 1954 Hurricane Carol, he could state that the picture was taken before 1954. Now, Mr. McCann is not an expert, doesn't purport to be an expert, and so much of Susan Carnaccia's testimony and what is recited in her reports is of that nature. She's dating photographs based on the existence of buildings and her knowledge of the records of when those buildings were built by corroborating and correlating and cross-checking against other records. She can see when those buildings were built and when they were demolished or destroyed. And therefore she can date the photograph, just like Mr. McCann did. So where's the, the expertise that's necessarily involved there? So I think we're getting into an area that is premature. I think we should cross that bridge when we come to it. Let's see what the testimony goes and how it goes. Now, also, it's not so black and white as Mr. Forsythe would have it. I have my little handy dandy copy of the rules. And the first rule on opinions and expert testimony is opinion testimony by lay witnesses. So lay witnesses in certain circumstances and to a certain degree can give opinion testimony. And I think that, you know, where there's a logic in a situation where you can correlate records from insurance maps and then a record from and then a photograph and say whether, and thereby date the photograph, I think that's within the realm of a lay witness opinion. Also, in terms of it being reduced to a report, we have the rule calling for summaries. And it says that Rule 1006 states that witnesses can prepare summaries. What she has done in many of these instances is, as I say, you know, I'm using an example, is taken a photograph, correlated it with insurance maps, building records, demolition records, newspaper articles about storms that demolished buildings, hurricanes that come through, and she's been able to date photographs and place things in a historical sequence. And she's been able to put that in writing, and that writing constitutes a summary. So I think it's premature. I think we're crossing a bridge that we don't need to cross yet. I think you have to hear her testimony, hear the quality of her testimony. And I would say this, that there was a link that I provided in answers to interrogatories. And Susan Carnacci estimates that there were, and that link represents a large portion of the documents that she's examined, not all of them. She estimates that there was about 300 documents that are in that link. I estimate that there's about 3,000, but I'll go with her estimate, 300. This individual has spent so many hours steeped in the history of Weekapaug that I think that she will come before you as an expert on the microfield of Weekapaug history. And I think that she's qualified by her efforts in this very case that produced these reports. So you know, just to summarize, because I've gone over a lot. Number one, there are narrow areas where that are specific to her expertise as a record manager. Number two, this is premature. And number three, it's not so black and white. Now, if in her reports, you find that she is straying over beyond her expertise, then I'm sure that we can reach some accommodation by redaction. But I don't think that's the business that we should be engaged in tonight. Thank you.
May I ask some questions?
Sure.
Is this person on your expert witness list?
Oh, yes, of course.
She gonna be deposed?
She's been deposed.
She's been deposed?
Yes.
Okay.
We hope to avoid deposing her, but given that the initial hearing to hear this motion was set originally for August, we went forth and deposed her, I think back in May or so, because we didn't want to delay.
Did the deposition wrap up?
I believe it did.
So your objection is only to the report?
Our objection is to her qualification as an expert on, forgive me, it's not a summary, it's 13 booklets of material where she has put markings. It's as if she's the synthesis of a title lawyer, a land surveyor, an aerial photo expert. She, in order to put forth the evidence that we've included in our snippets in support of our motion, she would have to wear about 7 different hats, and she's an archivist. And frankly, none of what she's doing is explaining with her expertise as an archivist how she located a particular document and putting forth the document without markings on it. Instead, she's pulling documents from all different sources, highlighting text, putting arrows, color coding parts that are important to her that serve her narrative. And counsel's attempting to use that mechanism to admit 13 booklets worth of evidence before this subcommittee.
Did those booklets come in via the deposition? Did they move to admit them as part of the deposition?
They were exhibits to her deposition, but
Right.
that doesn't make them exhibits before evidence before the subcommittee.
I'm gonna make,
No,
it-
but-
I'm sorry.
And as part of the deposition, were questions asked relative to her claimed expertise?
Absolutely. And she admitted
It's
she's
almost-
not a land surveyor or an aerial photography expert or a land title expert. She admitted those things.
I'm gonna make a suggestion here. Reserve on this motion. Reserve on accepting the reports at this time. I say reserve on it.
We need to make a motion.
Make a motion.
Any questions?
What, if we reserved, what does that mean that we have to decide later when?
Later on, you decide.
After we hear
Yes,
more information?
So we reserve on the motion to strike.
correct, yes.
Can I just interject one quick thing, and I'm sorry to belabor this, but I just have to defend Ms. Granacci. She's not my client, obviously, but you know, I'm obviously working with her. And this suggestion has been made that somehow she has not attributed the documents to their sources. Quite the contrary, she is extraordinarily conscientious in attributing every document to a source. And by the way, that's a subset of expertise. She is aware of archives that I wouldn't even know to look at, databases that I wouldn't even know. And I don't think an average person would even know to look at, but she's familiar with these sources and she can establish them as regular and respected places of custody. And I think that's what her expertise do.
Is there a motion?
I would move that we reserve judgment on the motion.
Is there a second?
Were we also reserving on accepting any of the reports, or is that?
If you reserve on the motion, I think that's sufficient at this time.
Second?
Motion made and seconded. Any discussion? Hearing none. Mr. Gagnon,
Aye.
Ms. Reynolds?
Aye.
I do vote aye. It's 3-2-0 to reserve vote on the motion to strike.
Right, the next motion is to compel Caroline Contrada's production of documents and information.
Just bear with me, Mr. DeSisto.
Cindy, how are you doing? You okay? Okay.
Now it's not. See. You have to come back.
Mostly Karen.
Maybe 10 or 6.
Forgive me, subcommittee. We have a motion to compel where we assert, the fire district asserts that Ms. Contrada has not produced certain documents and information. We set this out in our briefing, and I'm not going to go through the briefing in any detail. We know the subcommittee has already reviewed that. We have a situation where we did meet and confer to try to resolve these issues at length back in the summertime, and we're unable to do so despite the diligent efforts of Attorney Rubin. Ms. Contrada has lodged significant objections based on the work product doctrine that don't cover the time when she was acting in capacity as Attorney Rubin's investigator. So the district agreed to compromise to forego documents and communications between Ms. Contrada and third parties as to Spring Avenue Extension during the time when she was acting as Mr. Rubin's investigator in exchange for the identities of the individuals she met with. Those are discoverable facts rather than privileged documents. And so that's the primary issue that we have, is that Ms. Contrada's refusing to disclose individuals that she met with and discussed Spring Avenue Extension with in some substantive way when she was not acting as Mr. Rubin's investigator. We don't understand there to be any claim of privilege or work product or otherwise that could apply. She also objects on grounds of governmental intrusion. And we submit that discovery into Ms. Contrada's public posts or fundraising efforts do not constitute governmental intrusion on her freedom of association. And we know that, well, strike that. We're essentially looking for the identities, a list of the identities of individuals Ms. Contrada met with and discussed Spring Avenue Extension with during a time when she was not acting as Mr. Rubin's investigator. And I can boil down our motion to compel to that fact, or those set of facts. We don't believe that the identity of those individuals should be protected on privilege or work product grounds.
Maybe there's been some misunderstanding here. I asked Ms. Contrada to be my volunteer investigator, and we've actually pinned down the date almost within a week by reconstructing the records and correspondence. And the date was essentially April 1st, 2022. Now, my understanding from the motion was that Mr. Farside, on behalf of the fire district, was asking for the identity of people that she contacted in an attempt to outreach to potential witnesses and to locate potential witnesses subsequent to that date. I think there was a concession that he didn't need the notes or the actual correspondence, but he needed the identity of those people. Now, what I'm hearing, tonight, and maybe there's been a misunderstanding. If there has been, I'm sure it's mutual, or at least partly on me. But what I'm hearing tonight is that you don't want those contacts subsequent to April 1st, 2022, and you just want contacts that you might have had in trying to locate witnesses prior to April 1st, 2022. Well, I can tell you that she didn't try to locate witnesses prior to April 1st, 2022. So maybe, there's been some big misunderstanding here. Now, did she have some casual conversations with family and friends regarding, a situation that was brewing in Weekapaug? Possibly, we're talking about casual, familial type conversations that are of a trivial nature. So really, if what I'm hearing tonight is the case, this has much ado about nothing. It's a tempest in the teapot. So I guess I have to get clarification from Mr. Farside as to whether we want the identity of people that she outreached to subsequent to April 1st, 2022. Now, if it is the latter, the fact is that, Ms. Contrada, at my request, made a lot of efforts to reach out to people in the community. Now, you got to remember, we're not like the fire district where everybody's concentrated in continuity and people know their predecessors and people have been around for a while and they're all in the community. People who might have used this path are hither and yon, and they're spread to the four winds. So, the Weekapaug Fire District is free and welcome to hang out at bait and tackle shops, to go to bingo halls, to go to Sunday church dinners of old timers, to hang out in front of the little store down there. I can't remember the name of it, the grocery store in downtown Westerly, on a card table, trying to recruit people who might have used, or contact people, I should say, locate people who might have used Spring Avenue Extension. But I don't know that they get to piggyback on my work and on Ms. Contrada's work in trying to do that. Now, if we offer a person as a witness, sure. And let me say this, we're not hiding anything. I can represent, we're not hiding anything. People have faint memories, faulty memories. They're remembering another path. They think it's this, they think we're talking about the sand trail rather than Spring Avenue. So they say, oh yeah, I know about that. And then it turns out they're talking about the sand trail. So, but why should we subject these people to disclosure of their names? It really doesn't do any good, and it's really him piggybacking on my work. I'm sure that Mr. Farside and the management at the fire district went around to their members, who knows what, then they came up with a list of witnesses. I'm not asking him, who else did you talk to that's not on your list of witnesses? So either there's been a huge misunderstanding, in which case this is almost moot, or we are at loggerheads, in which case I'm right, so.
We found more common ground, the people that have used or may have used it are hither and yon. I think that's a good way of putting it. We're just looking for individuals predating the time Ms. Contrada became Mr. Rubin's investigator. So it sounds like we should treat this motion as moot, and he and I can have a conference and get this resolved.
Were we withdrawing the motion?
Is the motion withdrawn?
We'll withdraw the motion, yes.
There is a council meeting at 6 o'clock. It's 5:49 right now. Can we do the motion out of order for the compelled deposition testimony of the expert witness, which I believe is Mr. Priestley, an attorney?
Sure. Thank you, Mr. DeSisto. So the issue there is Mr. Priestley, we learned during his deposition, and he was deposed already. Mr. Priestley's work was funded in large part by Save the Bay. Mr. Priestley, and that became apparent at his deposition. Mr. Priestley was asked some questions about whether he had interacted with Save the Bay and received some directive or instruction from Save the Bay about the nature of what his report should be or should say.
Can you stop 1 second? I just
Sure.
have one quick question on the proper motion, because I know we jumped ahead, so I don't want.
This is a motion to compel. Another deposition for Mr. Priestley?
Is a motion to compel his testimony that was withheld at his prior deposition.
Okay.
So yes, we would have to reconvene his deposition, but we suspended his deposition for this purpose.
Okay.
Thank you.
And why was the deposition suspended?
I'm sorry?
Why was it suspended?
Right, it was suspended because he was instructed not to answer questions about meetings that he had with Save the Bay about the content and substance of his expert report. So Save the Bay funded Mr. Priestley's expert report. Mr. Priestley is an expert serving on behalf of Intervenor Contrada. Save the Bay came to an agreement, which we saw, with Ms. Contrada and her counsel to fund Mr. Priestley's work to the tune of about $15,000, which struck us as very substantive for a non-governmental organization. When asked certain questions about his interaction with Save the Bay relating to his work on this case, Mr. Priestley was allowed to answer. When asked certain other questions about meetings that he had with Save the Bay, he was instructed not to answer those questions.
And what was the basis for the instruction not to answer?
Common interest privilege. And we saw the agreement between Mr. Priestley and Ms. Contrada and her attorney, Mr. Rubin. And there was no mention in that agreement of a common interest privilege applying to the work And there was no allegation that Save the Bay was in a common interest privilege setting or that they otherwise had a common interest privilege among them. Instead, it seemed like Save the Bay had agreed to fund this expert work, again, to the tune of $15,000. And they did appear to have meetings where Save the Bay attempted to or did influence the content of that expert report, as it probably felt entitled to do, because after all, it was paying for that expert report. When we inquired what happened and what was said at those meetings, and whether Save the Bay, for example, asked about the pros and cons of the opinions expressed in Mr. Priestley's report, Mr. Priestley was then instructed not to answer on grounds of common interest privilege.
Who instructed him not to answer?
Attorney Rubin.
If I may, there was a deadline for submitting expert reports, and my recollection was it was December 1st, 2023. Somebody can correct me. Subsequent to that time, and this is what the testimony is at the deposition, Mr. Priestley had one meeting with Save the Bay, at which I was present and Save the Bay's counsel was present, and nobody else was present. I think that's pretty well established in the deposition. Mr. Priestley testified that it was in the spring of this year, 2024. My recollection, I was there, it was in January. So spring, January, people condense these timeframes. The deposition wasn't until roughly this July. So one meeting at which I was present, Kendra Beaver, then legal counsel for Save the Bay, was present, and Mr. Priestley was present. The report had already been made prior to that. Basically, the purpose of the meeting was what us lawyers, at least for my generation, call the problem of Mr. Green. We had to come up with more money. It wasn't really about the substance of the report, although it did get into the substance of the report of what the problems, what he had to address in his forthcoming testimony in this case. So I think that if Save the Bay, through their legal counsel, is putting up $15,000 for a report for Mr. Priestley's time and expertise as a title attorney, and then my client, through a GoFundMe page, is putting up the balance, there obviously is the elements of a common interest privilege amongst the counsel. He does not have to be a litigation counsel. And I just think probing what she said to an expert that's jointly hired by both of us, what Kendra Beaver having to say to him, gets into a sensitive area of mental impressions of counsel and so forth. And I think the common interest privilege, it doesn't have to be manifest in a writing. It can arise from the circumstance. They're chipping in, we're chipping in. We had a discussion about the money that then did get into substantive areas. I think that's privilege. And he did forthrightly testify as to all the other questions about what his bases were and what his opinions were. And he is, of course, a recognized title attorney.
The work product privilege, the work product doctrine would have applied to interactions between Mr. Priestley and Mr. Rubin and Ms. Contrada. Mr. Priestley attending a meeting of parent counsel between Save the Bay and Ms. Contrada, I think would also destroy any common interest privilege that would arguably exist there. In one breath, they argue Save the Bay has no interest in this matter and should not be deposed, which they argued earlier today. And in the other, they claim it has a common interest. So we submit it can't be both ways.
If I may just quickly, there's a difference between having an interest and having knowledge of facts. And that's come up, again and again. People donate to the GoFundMe page that Caroline Contrada has set up in order to fund this case. That doesn't mean they have direct knowledge of the facts.
Comments from our attorney?
Yeah, yes. I'm gonna make a suggestion on this motion also. Because the earlier motion to depose Save the Bay was granted, it seems to me at this time This motion can be denied without prejudice. Depending on what the deposition to save the bay discloses, perhaps some relevant information will be gleaned from this. Otherwise, now I don't think it's necessary because you granted the earlier motion to save the bay.
How does that help them get information from Mr. Priestley?
Well, here's the thing. Mr. Priestley has given a report and he's been proffered as an expert. To me, and it seems to me that this motion is attempting to discern whether or not Mr. Priestley's credibility should be brought into question because some other entity is supplying part of the funds for his opinion. Otherwise, his opinion is his opinion. Now, it may be that the deposition to save the bay discloses some facts that may call into question what Mr. Priestley did in his expert report. Then at that time, a request can be made to depose him again. But at this time, basically, there's been a disclosure that another entity made a payment for his services rendered. But the report is the report and his deposition testimony is his deposition testimony.
And a denial without prejudice will allow them the opportunity to reconvene or
Correct,
start a new deposition.
correct.
Any questions of Mr. Gagnon or Ms. Reynolds?
No.
Is the subcommittee ready to make a motion? And if so, what would it be?
I make a motion that we deny without prejudice, compelling Mr. Priestley.
Motion was made and seconded to deny the motion to compel without prejudice. Any discussion? Hearing none. Ms. Reynolds,
Aye.
Mr. Gagnon,
Aye.
I too vote aye. Motion to compel is denied without prejudice unanimously. Right. I think at this point, it's 6 o'clock. We have our regularly scheduled meeting of our full council set to begin it momentarily. I know we weren't going to finish this evening. I asked Attorney DeSisto where we were on the list, and correct me if I'm wrong, there's several more motions to be made. So I think we will reconvene this subcommittee and the motions at a later date. Do we need that in form of a motion, or we just stand adjourned?
You can stand adjourned unless you have a specific date right now that you'd like to set it down for.
There were all one. The 12th or the 26th, one of those could be. You would recommend the 26th. I would recommend it. We might need that for the. Okay, you wanna do?
Let's, adjourn now. Let's make sure that the lawyers can make it.
Okay. All right, so we won't decide a date certain at this point.
Correct. Make sure that the lawyers can attend.
All right, so I would entertain a motion to adjourn.
So moved.
Second.
Motion made and seconded. Any discussion? All in favor, say aye.
Aye.
Meeting stands adjourned at this point. Thank you.